if the Congress decided to give some other absolute jurisdiction, all that was done under that system would have to be perfected, would have to be reviewed, would be absolutely unavoidably delayed. And sometimes, people want delay. Sometimes the government wants delay. Sometimes the detainee, the defendant in a criminal case will want it, but you seldom find a person who is a detainee who wants things delayed. He wants it done yesterday. He wants it to be heard. And transparency is the hallmark of all this. That is, you can sit in the courtroom if you want to sit in the courtroom, and you can listen to it all. And you can see as they fight it in individual cases and understand that under the rules and under the procedures that are established, that the Supreme Court directed the courts to establish, these things are taken care of. I see a question way in the back. It's not for me, though. It's for you, Doug.
No, he has all the hard
Pardon
questions.
me, I didn't
I'm
mean
sure
to
it's
usurp
for
you. I didn't know if you saw it.
Let me commend Constitutional Project and the first rights for doing this. I think it's a wonderful contribution.
Your name, please, name, organization.
My name is Harvey Rishikoff. I'm affiliated with the ABA, Standing for the National Security Law, and the National War College. But I'm really asking in my private capacity because I've written on this subject, and I so want to pose a series of questions. The first is, you're also handing out at the same time a critique of the national security courts, as you are also having this issue of the review of the courts in Habeas. And many have argued the way the Congress has acted now, we have created a national security court. It's the DC court, the DC courts, the trial courts for these Habeas cases, and then we've designated a specific court of appeals. So we have created, in a way, a national security court system by designating these courts as developing a special area of expertise, which I think the report is arguing that is a good thing. And the second issue sort of intriguing by the report is an assertion that the Congress should stop, that Congress should not continue to act, even though it clearly has a constitutional right to do so if it so chooses. But the group is saying, no, the Congress should stop, that this is an issue in the area of the courts. So my question, there are two other areas in which the courts have been very, very active, involved in this area of related behavior. One is, of course, is the issue concerning of when do you give the Miranda right. That's become a hot issue.
Boy, is that an issue?
So I'm kind of curious as whether or not you as a group, the panel is of the opinion that the court should start getting involved in the decision about how Miranda is delayed or not in the context of national security or special public safety issues.
Well, it's a great issue, but I would say that I would choose not to delve into that. It's a separate matter. But it's also a very important matter. And the Supreme Court has, in a sense, thrust some of it back upon the trial courts and the prosecutors to deal with it, and the law enforcement people themselves in the executive branch to deal with it. So I don't think we should go into that at all in this matter.
The second issue is...
The report doesn't cover it, is what I'm
Right,
saying.
I'm curious, because once the report starts asserting what's appropriate for Congress and what's appropriate for courts, a natural issue that's going to flow from this is what other related areas should there be similar senses of divergence of expertise?
And I think that's a legitimate exercise.
Yeah.
I don't think you can say, well, we've decided that this is the procedure. And the courts have decided, and they've affirmed us. Therefore, you're out of order. There's no reason for that discussion. Quite to the contrary. There is always a reason to explore it and to see what impact you've had and whether you were thorough enough, complete enough, and correct enough under the law to do it.
Because the other related area is targeted killing. Because as you know, in the Israeli courts, their decision has been that they can review actions that have been taking place by the Israeli military. And their argument is for the same issue is almost Habeas related. You're going to take someone's life. What are the procedures and process by which you decide to make that decision? So it's another related issue this group, I think, this report starts to raise is what is the appropriate lanes for what the executive branch says it's going to be able to do under its authority and power, and what is reviewable by the courts vis-a-vis their understanding of their constitutional mandate.
Well, I think you are giving us credentials I'm not entitled to exercise. I don't know the answers to those things. Doug may have some views on it, But I think, again, it's beyond our report here. But if you suggest it should be a part of that, I would say it would be a good idea to construct a response to the report that you believe needs to be examined and covered.
Third and final is, as you know.
Oh, he may have a comment on you.
Well, no, I may not. I would say that, I think this report deals specifically with habeas. And of course, habeas is a civil process, so the Miranda warnings don't come into play in habeas. And if we're talking about habeas, we really are talking about the detention authority of the government versus targeted killings and that military issue in the context of the laws of war. I think what this report does is it demonstrates and I think clearly indicates that the courts have a firm handle on habeas, on the substantive standards and the procedural framework within which habeas cases are decided. And I agree with Judge Sessions that while your questions are really important questions, they're outside the scope of this report and probably something that, would be better tackled in a different context.
I guess the final habeas related question.
By the way, in that regard, I would have another observation. Because you have these questions, we have, first of all, our CEO is here, Virginia Sloan. And second of all, the head of this project is here, Ms. Franklin. And they would welcome receipt of those things as potential things that the Constitution Project might look at.
Sure. The last is a decision by Legrand, that it's been decided that Legrand does not fit under the current habeas frameworks. I was curious as to what is the reaction of you guys who've been involved in this program as to your reaction to that particular decision.
I would hasten not to give you my reaction, but I think it's not part of the report, and we probably shouldn't delve there or even go there. It again reflects a troublesome area that is going to be a concern to people, and necessarily it should be discussed, but it's not part of this report.
And I agree, and I think the fact that you had as a scholarly a district court opinion by Judge Bates in that case, and then the Court of Appeals decision that reversed that, to me is reflective of the controversy and the difficult issues that arise. I personally think it's hard to draw the lines that the Court of Appeals drew. On the other hand, my clients were all locked up in Guantanamo, and that's been the focus of my case, and again, I think that's been the focus of this report.
Great, thanks.
You had a good bunch of questions.
Getting a blind squirrel finding that one.
She's trying to put her hand up.
Christine Nixon, United States Justice. I agree, the Congress trying to address the two issues that the courts are addressing now, which is the scope of detention and the procedure for making that determination, would probably be a disaster if they come out with vaguer standards, and the courts would have to interpret them anyways. But what about legislation coming in to establish some sort of review system? I don't mean appeal of these decisions, I mean review 5 years from now, 10 years from now. Because I don't know of, and maybe you do, a judicial mechanism or a civil procedure mechanism that allows for review of a habeas case like this. And you couldn't bring a second petition unless there was, I'm not really sure what the.
Would be a successive petition,
Would
would be
be-
a higher standard.
And you'd have to really show a change in facts. What would you show?
Might
The
show
war on
us,
terror has ended?
yeah, a cessation in the hostilities that caused detention in the first place. I think it's a very difficult question, and what makes it difficult is just the fact that we are dealing with a quote-unquote war, and there are many who question that paradigm in the first place, but we're dealing with a war that potentially has no end, and certainly has no clear-cut end. But it does seem to me that that in and of itself is an area where the courts, I believe, will be open to future cases that say, okay,